Let's picture a scene. A serious accident happens, and just like that, a family's whole world is turned upside down. And beyond all the hospital stays and the long road to recovery, there's this whole other side to it. A spouse has to give up their job. A parent moves in to help with just the basic day-to-day stuff. A friend might spend hours every single week driving to appointments, making meals, or helping with washing and dressing. They're doing all this out of love, right? There are no invoices, no paychecks.
And that brings us to a really huge question, one that most families in this spot don't even think to ask. Can the massive value of all this unpaid, informal care actually be recovered in a compensation claim? I mean, it kind of feels like it shouldn't be possible, right? It's family. It's what you do for each other.
Well, in Scotland, the answer is a really clear yes. Okay, so how does the law actually handle something like this? Well, it doesn't just recognize this massive contribution, it actually has a specific name for it. And we're not just talking about some nice idea. This is a solid legal principle we're dealing with. It's called gratuitous care. Now, that might sound a bit, stuffy and formal, but the idea behind it is actually super simple. It's care that's given for free by family or friends, and the law sees it as a real recoverable financial loss in a personal injury claim. And believe me, in serious cases, this can be an absolutely huge part of the final compensation. So the logic here is really important. The person who caused the accident, they created a need for care that just wasn't there before. The law basically says, look, they're responsible for the economic value of that care, whether a professional was paid for it or not. The fact that a loving family member stepped in for free doesn't make that value disappear. It just means the family shouldered that cost themselves. The law's job is to shift that cost back where it belongs. And you might be wondering, okay, so who counts as a carer? Well, the law is actually incredibly broad on this. It's not just a husband, wife, or parent. It could be a child, a brother or sister, a close friend. Really, it can be anyone who steps up to provide that essential support. The legal right to claim isn't hung up on a specific family tie. Okay, but this brings up a really, really important point. Not all help is treated the same in the eyes of the law. So what exactly counts as care that you can legally claim for? The law draws a super clear line here. It's all about valuing the practical, hands-on help that's needed because of the injury. We're talking about things like personal care, helping with bathing, dressing, or domestic stuff, cooking, cleaning, things the person just can't do anymore. Even driving them to appointments, or just being there to make sure they're safe. Now, what's not recoverable is the emotional side of things, the companionship, the love. The law doesn't even try to put a price tag on that. It sticks to the tangible tasks, the things that have a clear economic stand-in. Right, so if this care has a real value, the next question is obvious. How on earth do you calculate it? How do you put a number on all those hours of help? Well, there are basically two main ways this gets worked out. The first one, and this is the most common, is what they call the hourly rate method. It's pretty straightforward. They take a standard hourly rate, usually a bit less than what a professional agency would charge, and multiply it by the number of hours of care. Simple math. But what if a carer had to actually quit their job to help? That's where the second method comes in, the lost earnings method. In that situation, you can actually claim for their real lost net income. The only catch is that giving up their job had to be a reasonable thing to do in the circumstances. And this is why that second method can be such a game changer. A carer's lost earnings, especially if they were in a well-paid career, can be way higher than the standard hourly rate calculation. It really makes sure the compensation reflects the true financial hit the family took. And it's also really important to note that a claim like this covers everything. We're talking about past care, all the help given from the day of the accident right up until the settlement. But it also covers future care. That's projected forward based on what the medical experts say about the person's long-term needs. Okay, so with all that in mind, what's the single most powerful tool a family has to support a claim for this kind of care? What's the one thing you can do? Well, it's probably simpler than you'd think. It's this, a care diary. A simple day-by-day record of all the care that's been provided. I mean, trying to remember all this stuff months or even years down the line, it's almost impossible, and your memory just isn't as reliable. A diary that's kept at the time is without a doubt the strongest evidence you can have. So how do you actually do it right? It's 3 simple steps. First, start it immediately. Seriously, don't put it off. Second, get the details down. You want the date, who did the caring, exactly what tasks they did, and how long each one took. Be specific. And third, be consistent. If you do it regularly, it paints a really clear picture of the true pattern and intensity of care, and that is just incredibly powerful evidence. Okay, let's pull all this together. What's the bottom line here? What are the key things you absolutely need to take away from this?
I think the biggest message is this. All that effort, all that care from a family, it isn't just a nice thing the law overlooks. No way. It's recognized as a real, tangible contribution that has a real economic value. It's about making sure that financial burden lands on the person at fault, not on the family that was just trying to help.
And one last practical point. It's really important to know how the money actually gets paid out. The award for the care is paid to the injured person, right? It's part of their total compensation package. It's not paid directly to the brother or the spouse who did the caring. Now, there's obviously a strong moral expectation that the injured person will then use that money to thank and reimburse their care for everything they've done.
So, in the end, it really all boils down to this. The law can't put a price on love. It can't value companionship. But it absolutely can, and it does, put a value on the practical, physical work of caring for someone. So the question I want to leave you with is pretty simple. Is your family's incredible contribution being counted?